10 Mistakes That Can Sabotage Your Criminal Case by J. Jeffrey Lee, Attorney at Law, Certified Criminal Trial Specialist. Mistake number 1. Thinking that you don't need an attorney if you're planning to plead guilty. Many people prefer to believe that an attorney has little effect on the outcome of a case, so they do not have to regret how little time and money they invested in picking one. Perhaps they think an attorney can only help when the case is a clear winner. The victorious legal argument is out there and waiting to be announced, and the defendant just needs any available mouthpiece to show up and deliver it, like pizza. Or, if a case is a sure loser, it's best to just save their cash, place their hands against the wall, and wait to be slowly marched away to prison. Any attorney will be fine, since they don't have much control over the case anyway. The problem with either line of thinking is that a case is rarely already determined to be a winner or a loser. Its status can change in an instant, based on many factors, including whether you gave a statement, what witnesses are found, and yes, the arguments that your attorney makes. It is simply too early to be making hasty decisions about not needing an attorney, or thinking that any attorney will do. I've never once heard a convicted felon brag about how much money they've saved, or how quickly they got from jail to prison by rushing into a guilty plea. If anything, they usually feel the exact opposite way. Before making any decision, you need to speak with an attorney. Put your ego aside, get your wallet out, and accept that you do not know enough about how the criminal process works. Even if you do know it all, it's tough to get the proper perspective with your head resting on the chopping block. In some courtrooms, you cannot plead guilty without an attorney. In others, you can, even though it is highly discouraged. Some defendants joke that this is for job security when the judge requires them to hire an attorney. But it's actually the court's way of protecting you from getting railroaded. Think about this. The same police who sneered when you lawyered up will certainly do the same thing if they get charged with a crime. Heck, even attorneys and judges hire an attorney when they get in trouble. That should really tell you something. You need an attorney even if you're going to plead guilty for a number of reasons. Negotiating the best possible agreement, making sure that you understand what evidence would be allowed in your case before deciding that you have no chance, and understanding what alternative sentences are available. You need an experienced negotiator. Point A. Getting the best deal possible. Imagine that a prosecutor tells you that you can plead guilty to a charge and receive 10 days in jail. Is that a good deal or not? The prosecutor then tells you that this deal is only good for the next few minutes. Don't be pushed around by these tactics. Tell them that you need a new court date to hire an attorney, and actually get an attorney before the next court date. Point B. Properly documenting the terms of the negotiation. This happens both in the court proceedings and in the plea paperwork. When the judge or prosecutor says something unclear about the negotiated agreement, your criminal defense attorney may jump in there with a tiny correction for the record. Perhaps your attorney doesn't like the way the prosecutor said jail sentence of 2 days without explaining that you had already served 2 days. So he or she says, with credit for 2 days already served. You might not have any idea what that discussion is about, but that back and forth is your attorney fighting to make sure that you receive every possible benefit. What if you plead guilty without an attorney and go to jail, and on the day you expect to be released, the jailer tells you that you have 2 more days to go? You realize now that the prosecutor must have forgotten to give you jail credit for the 2 days you spent in jail before you bonded out. Since you didn't have a lawyer to double check or even complete the paperwork and ensure that it was correct, you have no way to get it straightened out. Point C. Knowing the additional consequences of your plea. Imagine that you plead guilty to a domestic assault because the prosecutor offers you a time-served plea. Later, when you try to obtain a handgun permit, you're told that you can never own a handgun again. If you had hired an attorney, you would have known the consequences of entering that plea beforehand. But now it's too late. Perhaps your lawyer could have even negotiated the offense down to a simple assault, which would have carried less penalties. Since you only talked with the prosecutor about how much jail time was involved, you never learned the additional ways that the conviction would affect you. You will know what chance your case would actually have. You might be thinking, Well, I know that the police have a lot of evidence against me, so what's the point of fighting any of it? Let's say that you receive a DUI charge. Do you know whether the police made a lawful stop of your car? Do you know whether the police followed the correct instructions when they gave you the field sobriety test? Are the police still using a test that the court has decided is unreliable and inadmissible? It's possible that the evidence that would be used against you was obtained illegally and could be excluded from the trial. If there is a good argument to keep that evidence out of trial, your attorney can file a motion to suppress, and the prosecutor will have to explain why that evidence should still be allowed to be used. If you don't hire an attorney, then you will never know if you had a chance to win your case. Even if you hire an attorney, and it turns out that your best option is to enter a plea, at least you won't have to wonder what might have been. You can't go back to court a year later and say, "I know that I pleaded guilty before, but I'm thinking that maybe I should have gone to trial. Can I get a do-over?" It's sort of like you open an old trunk in an attic and found some antique jewelry inside. It might be worth thousands of dollars, or it might be complete junk. Wouldn't you take it to a professional appraiser before selling it? Or would you rely on the people who wanted to buy the jewelry when they said it was worthless? Your attorney will tell you the value of the evidence that you have in comparison to the value of the evidence that the prosecution has, how the evidence compares to the statutes and jury instructions for that particular offense, and what the risks are if you don't take the prosecution's plea offer and go to trial. Just like the jury appraiser, take your case to the legal professional before selling it cheap. You may be able to keep your record clean through a diversion. If you meet certain requirements, you may be eligible for a diversion. Diversions come in two forms: pretrial diversion and judicial diversion. With a pretrial diversion, you never have to enter a guilty plea. Instead, the prosecutor might allow you to reset your case for an agreed length of time to see if you can keep from getting additional charges. At the end of that probation period, your original offense may be dismissed. This is certainly the defendant's preferred choice between the two diversions, but it is rare and can only be taken if the prosecutor agrees to it. You should almost put this option out of your mind because prosecutors are getting really stingy with this one. With a judicial diversion, you must actually enter a guilty plea to the offense. Your attorney needs to ensure that you are eligible for judicial diversion before you enter the plea. If the judge grants your diversion, your sentencing is deferred or held off for a probationary period to see if you can keep from getting additional charges. If you make it through probation, you can return and get the offense taken off your record. The biggest difference between the two diversions is that if you get in trouble during the judicial diversion probation period, then you have already pleaded guilty. You will no longer get the original offense taken off your record, and now the sentence that was originally held off will come back and bite you in the butt. You shouldn't really compare the two types of diversions with each other because you won't get that choice. Instead, you should compare taking a diversion to not taking one. The advantage to both diversions is that you will not serve any jail time and you have all of the records completely erased. It is the same result as winning a trial after jumping lots of hurdles. One local judge calls diversion the Cadillac of probations. Diversions are an excellent option for first-time troublemakers who can stay out of trouble and want to keep their records clean. Many people who prefer to avoid the embarrassment, expense, and delay of going to trial even if they maintain their innocence because they believe that the offense will ultimately be erased anyway.